governor that will be coming. Brown terms out in January. And you can already start to see, if you look closely, because it's a funding issue, that one or more of the candidates are coming out with the concepts of workers' compensation reform. Now, when you hear workers' compensation reform in today's terminology, it is not good for you. It means that they're going to reform it to the benefit of the injured worker. Gavin Newsom already has been getting money raised by the California Applicants Attorneys Association, and he's actually appearing at one of their fundraising events. And so he's won so far. He's already come out and been identified as one we just need to be concerned with from an employer standpoint as we move towards the election. Doesn't mean he's going to be the worst. It doesn't mean he's going to be the best. It just means he's active, and we have to be aware of that activity. The other thing that we should be kind of just be aware of as employers, because I've been talking to this group for about 6 years, and we've seen a lot of change even in the 6 years. When pure premium rate is down overall, as it is, there's not a lot that happens in the legislature. It just doesn't become an issue. They go after other issues that are more important to Californians, like the environment and things like that. Right now, it's expected that we're going to be quiet certainly through January, and then maybe even thereafter. If you don't know this, workers' compensation carriers have continued to pay less and less of the premiums earned into the comp system, creating more and more profits. So in 2016, they spent 94%, and in 2017, it went all the way down to 91%. Last time I talked to this group, I think I was telling you that some of the big concerns we had was the medical cost containment provisions. That is what it's costing to maintain a workers' comp case from a claims examiner standpoint. And that too has gone down, and it's down by 5.3% this year. So all of these things are of great benefit to the insurance industry. Whether they pass it down to the employers or not is another story. But for those of us who've been doing this long enough, I can tell you that if we were doing this 15 years ago, our premiums would be 2 or 3 times what they currently are. Wow. And we remember those days before the changes in the law. Right now, there's a couple of bills that are out there, and there's a couple that we might see coming. There is a case which we're going to talk about in a little bit, which is currently before the California Supreme Court. It's called King versus Comp Partners. And it is a case that could have a significant effect in both the group medical setting and in the workers' compensation setting if the Supreme Court rules the way it does. And if that were to happen, we've already been told that the legislature will have to pass immediate emergency legislation to protect the employer's interest as a result of this one case. And again, I'll talk about it in a little while, but the case basically is attempting to hold utilization review doctors in both the group health setting and the workers' comp setting for medical malpractice if they make a determination or non-certify something and then the employee has some damages. They're allowed to sue this reviewer who was never a doctor to that patient for medical malpractice. And that can't happen because the systems, both in the group health and the comp setting, will fail. So far they've been successful, but the Supreme Court has granted it, so they're looking at it. So that's one thing we just have to look out for in the future. Also in California recently, we had a sudden resignation of the director of the Division of Industrial Relations out of the blue. Christine Baker retired on March 30th of 2018. And currently we have the Undersecretary of the Labor and Workforce Development Agency running the Division of Industrial Relations. This governor will not replace that position, but will allow the new governor to replace that position. So we're going to have an interim person in that position until then. A couple of the bills that are important. A bill that passed the Senate on June 27th, just last month, was AB 2046. This is a good bill for employers. What it does is it allows various state agencies that get information about workers' compensation fraud to share it with one another without any ramifications of disclosing the information that they've received. They can't be sued and all that other stuff. So it's a good bill. It's a non-cost bill. It just allows them to not get in trouble for sharing information. It used to be you'd ask a state agency and they'd say, we can't do it, there's privacy rights and all this other stuff. Well, this allows that to happen. There's some CURES bills that I'm not going to get into. CURES stands for the Controlled Substance Utilization Review and Evaluation System. And these are just kind of monitoring bills. We have a significant problem with opioids in California. It's nationwide, but California is worse than ever. So these bills are a way for them to monitor how much prescription drugs are being dispensed. I'm going to tell you about a doctor in a minute to give you an idea of what these guys are doing and how it affects the premiums. It's just unbelievable. On an aside note, I'm not going to talk too much about that, but you know that marijuana is now legal in California, that doesn't mean it's legal in the workplace. It's still federally not allowed. There's also a statute in the California Labor Code that says that, the Insurance Code, that says that we cannot pay an insurance company to reimburse them for medical marijuana in a workers' compensation case. So right now, the way it is somebody who is legitimately successful in treatment with medical marijuana cannot get it for a work-related injury. And as a defense lawyer, I say to myself, that's a good thing, right? Well, that's fine except for when the alternative is opioids. The opioids are significantly more costly and highly more addictive. And quite frankly, if given somebody an edible marijuana brownie is going to have the same effect or a better effect than the costly oxycodone, I'd rather there be some methodology by which that can be given to the injured employee. I think it's better for the employer and the employee. But right now, the law is the way it is. In any event, we're shortly going to be discussing a new case called the Rice case, and one of the most significant cases that has come out this year. So we have what's called apportionment in California, and for those of you who have done this long enough, you will remember in the 80s and 90s and into the 2000s that if an employee came to work for us with pre-existing conditions, and we were the straw that broke the camel's back by even 1%, we would buy the entire claim. And then the law changed, I can't remember when, but maybe 10 or 12 years ago, when SB 899 came around, and they amended the labor code sections to say that you, the employer, are only responsible for the disability that your injury caused. We call that apportionment. So the apportionment laws changed, saving employers significant amounts of money and frustrating the living crap out of the applicants, employees that got injured. To this day, it frustrates the living crap out of them, and they're constantly trying to change the law, and I'm going to show you a couple of those bills too. But to tell you how far the pendulum has swung in favor of the employer, we're going to talk about the Rice case. And what the Rice case says is this, and you all have to use your imagination for one moment. Imagine me a striking fireman who develops cancer. And for those of you who know, if you're a firefighter or police officer and you develop cancer, it's presumed that it came from work, shifting the burden to the employer to show it wasn't work-related. Well, you have to also imagine, although this part is actually true, that I have a defective gene called the ATM gene mutation. I know that because I've had genetic studies. And that genetic marker causes cancer. So in that case, the Rice case, which we'll talk about more, basically says that if I never have a symptom from the ATM mutation, but I just have it, they can still apportion away permanent disability to that genetic asymptomatic factor. That's how far the pendulum has swung the other way. So, and that it's really scary, because what people might start doing, which could be very costly, is everyone might start getting genetically tested in every workers' compensation case, and we want to avoid that. But we'll talk about that in a minute. This case is so egregious, according to the applicant's bar, the employee's bar, that they introduced a bill before the case has finally been implemented across the state that would overturn the Rice case. It's a bill just designed to overturn that one case. Now, that tells you how scared they are about it, and the way they couch it so that it sounds really good to the public is that it would prohibit physicians from using race, gender, national origin, or genetic factors in apportioning permanent disability in California workers' compensation. So a lot of that sounds really good, because nobody wants to apportion to race or gender or ethnicity or anything like that. We would never want that to happen, but genetic factors is another whole thing. So the language, just so you'll know, when they drafted the new legislation, which is still pending, is that this decision is, quote, abhorrent and violates every legal norm, undermines the legislative intent, and abuses the dignity of every injured worker in California. That's how strong they feel about this. So my view, I'll give you when we get to the Rice case in a little while. There's a couple of other bills you want to know about. SB 1086 only pertains to police officers and firefighters. Nobody's got that here, but just to tell you that that effectively extends the statute. There used to be a limitation on how long a police officer and firefighter had to file a claim. It used to be 240 weeks. They temporarily extended that to 420 weeks, and now they've permanently extended it.
So that was 5 years from their last date of work to now 8 years past their last date of work to file these presumptive claims involving heart and cancer, those kinds of things that have a latency period.
And the reason nobody wants to, the reason these things get passed with police officers and firefighters is nobody wants to deny them anything. So they get every exception in the world. And maybe they deserve it, but we also pay for it. We, the people, pay for
Taxpayers.
it. So, yeah. They passed a new bill. I don't know if anybody deals with janitorial here, but this bill was designed just for janitorial companies, and it basically says that if you work for a janitorial company, you are presumed to be an employee, not an independent contractor. So anytime you're doing work for that particular person, that is, you're going to be considered an employee, and they're going to have to establish all of the requirements, including the new recent requirements, that they are independent contractors. So that's still out there. There's a bill out there that it's been up 4 or 5 times. It's been vetoed by Governor Brown each time, and now it's really very, very specific. But it was a bill that would also significantly change the law on that issue of apportionment that I told you about. The way they now have couched the current bill is that if an employee sustains an injury at work that results in breast cancer, that person is entitled to permanent disability in situations where other injuries would not be entitled to permanent disability. So, for example, if there is skin disfigurement because the person developed breast cancer from work, that skin disfigurement would amount to an increase in permanent disability. And the truth is that nobody has too many issues with that. There aren't that many cases that pertain to it. But if you saw the way this bill used to look, it used to look and read that if there is, it would be illegal for there to be any finding of less permanent disability because you're a woman or because you're a minority or anything else like that. So it failed 3 or 4 times. This is now limited back to breast cancer, and it'll come up probably after January, and it may very well pass. There's not too many people that are opposed to that right now. Another interesting bill, AB 1749. This bill arises out of the Las Vegas shooting, and you guys might all hate me after this, but I have a little bit of a problem with this bill because it's these kinds of bills. They're produced out of emergency frustration instead of thought. We did this. This happened also in the San Bernardino shooting. They did all kinds of things as a result of that one. And it's done this way because politicians get the benefit of saying, "Look what I'm doing." But this bill would provide that when any peace officer is injured, dies, or becomes disabled, by engaging in what they do, protection or preservation of life, within or without outside the state of California, even if they're not acting under the direction of any one of their employers, they're considered an employee and entitled to workers' compensation benefits. In Las Vegas, there were a number of police officers that were attending the concert at the time of the shooting, and they were injured. And there's a question of whether they were injured because they were doing apprehension, because nobody was doing apprehension because the guy was far, far away. But that was the argument that they made. And the long and the short of it is they want this bill to cover those people whenever and wherever they are. So somebody's on a family vacation in Europe and they see a purse snatcher and they decide to go after them and they get themselves shot or killed, that would be a workers' compensation case in California. That's that bill. They've just added licensed professional clinical counselor, including marriage and family counselors, as to those who can treat work-related injuries. They were used to not be considered able to treat under Labor Code Section 4600, so that's good. There's a recent trend and an effort to pay workers' compensation benefits through debit cards. This, for us, is going to be a complete mess, but what would happen is an injured employee would get a credit card from the workers' compensation carrier, and every 2 weeks, the workers' compensation carrier would be charged with putting the money in, and then the employee would have to go use his debit card to take the money out. So they've tried it. They've been trying it for about 10 years. This new bill allows State Compensation Insurance Fund to enter into a pilot project where they could pay it that way without ramifications. And they would have to be all kinds of regulations as to how this would be done, and what about somebody who can't access the money for whatever any reason. The people that are not legally entitled to work in the United States are scared that it's going to be an identification type thing. Anyway, I'm not sure it's going to work, but they've been trying to do that for a while.
There have been lots of things like that. They would have to present the card, and then that card would be charged, the card would charge the carrier for the item. So this is a rollover from that, because nobody wants a check who gets a check? Who goes to a bank, right? That's what the process is.
Right. So the last one I want to talk about is, you guys that have been doing this a while might remember, we had vocational rehabilitation, which used to cost us $75,000 to $100,000, then they limited it to $30,000, and then they limited it to $16,000, and then they got rid of it altogether. And now they have the supplemental job displacement benefit along with the return to work fund, which you, the employer, funds every year, and it's $120 million is funded by what you pay in your premium dollar. This money is supposed to help return the employee back to the labor market. We all know that that's not what really happens with it, but what is happening is the money isn't, the $120 million that's raised every year is not being spent. And historically, when money like that is not being spent, it is pushed off to another governmental agency. The governor just spends it someplace else. And there's a bill out there that would say you have to spend all $120 million per year and not accumulate any more money, so that benefits would go up to each of these injured employees. So that's just kind of a little bit about what's going on in the legislature. If you haven't read the news recently, the big trend in California is we've been throwing doctors in jail left and right. Doctors who I used to call the leeches in the workers' compensation system. And trust me, when you see what part of your workers' compensation premium dollar goes to medical, you'll understand why it was so important for the various state agencies and county agencies to go after the doctors in workers' compensation. And you've heard about Drobot Jr. and Drobot Sr. Drobot Jr. finally went to jail this week, and he's doing 7 or 8 years. He ran a pharmacy. Drobot Sr. is still cooperating with the feds, so he's not going to jail till he's done cooperating, but he got sentenced, I think, to 4.5 years. So putting some of these people out of the business, Dr. Sobel, and every month we get a list of another group of doctors that are no longer allowed to practice workers' compensation. And so the big issue there is what happens to all the money that they have charged. I was just looking at one doctor, this was from this morning. He just pled guilty to a conspiracy on compound drugs, another joke in workers' compensation. You know, you have a lotion that combines a variety of drugs together, and because they're not scheduled, they can charge 100 times what they would charge for the drugs separately. This one doctor who faces up to 5 years in prison, in 1 year, he was one doctor from one pharmacy that he was involved in this scam with, and he billed $1 million. One of the pharmacies total billed $14 million in 1 year for these, these compound drugs that, believe it or not, were designed for animals. I mean, that's what compound drugs were designed for. So that tells you the extent of that. They're going after the doctors pretty hard. The problem is that they're not protecting you guys and the insurance carriers very much, because you guys are the victims. And the victims are entitled to restitution. But most of these guys don't mind going to jail for 4 or 5 years. Just don't take their $100 million that they have sitting in offshore bank accounts away from them. That's been a problem. We have all these lien consolidation hearings before the Workers' Compensation Appeals Board, where we're trying to dismiss the liens, because even though they're in jail, they're still trying to get their money from it, because there's still an argument that not everything they did was fraudulent. Some of it was okay, so we want our okay money. And it's a joke because we go down there and there's a million people in there and nobody knows what to do about anything, but it's very frustrating. The good thing is we've gotten rid of a lot of bad people in the system. The bad thing is historically, and I've been doing this for 36 years, the bad people are just replaced with different bad people. It doesn't go away. And it's very interesting. It's completely different in the South than it is in the North. They don't have the, you go past Bakersfield and stuff like that, they don't have any of the problems that we have in the South. We create most of the problems down here, and the people just abuse the system tremendously. So that's a little bit about that. Want to talk to you about just something that has happened in the last 5 or 6 years, and then we're going to start talking about cases. As a defense lawyer, I used to get a workers' comp case, and I would get the employer would say, "This never happened, and we want to fight the case." And I would say, "I love you because I want to fight the case. It's a bad case, and if you don't fight them, like what happened in the 80s, you just create a lot more bad cases." In the 80s, we had a number of law firms that they would file continuous trauma claims, and every case had a buildup of medical and always settled for $1,500. Because $1,500, I'd rather pay him and get the file closed than pay Perlman to defend the case. That was fine until there were 48,000 of these $1,500 settlements. And so they had to put a stop to it and stop paying those benefits. And as soon as they did, most of those cases went away in time. Well, we're at a different stage than we were 5 or 6 years ago. When we get a file now, most of the time our carriers say, here's the file, it's a denied case, and you have authority up to $10,000 to settle the case now. So settle the case now. And, that's us throwing $10,000 out on a case that we previously would have defended. But the rationale is actually there, because that case is going to cost $15,000 just to get to wherever we're going to get to. So we're back to a trend now of them telling us to settle our cases. And I can't tell you that they're wrong in the short run. It's concerning me in the long run. But my recommendation to you as an employer is, if you have a case that you truly do not believe is work-related, and it doesn't have to be hiring me, it can whoever you're going to hire to defend the case, push your insurance company to not roll over on that case. Number one, it sends a bad message to all the rest of your employees. Number two, it sends a bad message to the industry. I was at a case yesterday where, in the old days, the case would have been worth $2,000 or $3,000, and the carrier wanted to pay $25,000 just because they didn't want the file hanging around. They wanted it closed. Well, they don't really care. They're going to turn around and charge you. It's going to come out of your premium dollar at some point in time. So just kind of be aware of that. Stay engaged in your cases if you can, and we'll talk about why that's so important when I get to the last part of protecting yourself. So let's talk about it. Anybody have any questions about that, or anybody have anything that they want to talk about look, we are a small enough group, and I'm more than happy to discuss anything that anybody wants to talk about. We're here to I don't want to say entertain you, but we're here to give you information that we hope will be helpful to you. So if anybody has anything that they want to talk about, or any experiences that they've had that they want to share, please, it'll be a lot more fun if people are engaged.
Your first couple of slides are what not to do in terms of safety violations and how people get hurt at work. Barry always finds something entertaining for us as far as that's concerned. Where was that one taken? Do you know?
No, I don't remember. I knew where they all were.
At one point. This is my favorite, one of my favorites. Scaffolding. I'm going to put a ladder on top of a ladder. We know and gas is cheap there, wherever they are.
That was.
Anybody notice anything wrong here? Water and a metal, and electrical, and a metal ladder. Come on. Let's move.
While she's doing that, I'm going to do the first case.
Go ahead.
So we have a case, it's on page,
I got it. Later. I got it.
18, 15?
Go back one.
Anyway, it's called Schulk. She'll tell you the page in a minute. There has been
Your page number 15.
there's been a little bit of a change in workers' compensation
Slide 15.
death cases. Anybody have a death case ever at work? Thank
Yes,
goodness.
yes.
We had one.
Yeah, two.
Thank goodness. So, in this case and other cases that have followed recently, we have a guy that was driving to work in a company vehicle when he suffered a fatal heart attack. Generally speaking, you guys probably know when you're driving to and from work, it's not work-related, the going and coming rule. But when you're when you're in a company car, that can be considered work-related. So the employer denied that the heart attack was work-related because the employee smoked a crap load. He had high cholesterol. He was super heavy. And he had elevated counts on every blood test that you could possibly see. He was a walking time bomb for a heart attack. Now the carrier, for Xerox in this case, made a drastic mistake, and they went to an agreed medical examiner, AME, for those of you who don't know. An agreed medical examiner is a doctor that the parties agree upon to make a decision of whether or not the condition is work-related. Well, let me tell you, in California workers' compensation, when you have a death claim where you have little ones running around and a wife that's got no husband, no income coming in, to go to an agreed doctor, trust me, that doctor is going to do everything they can to find that death to be work-related. So, in this case, the doctor said exactly what he needed to say. He said, listen, 90% of what caused this person's heart attack was work-related. I'm sorry, was not work-related. It was related to his obesity, it was related to his drinking, his cholesterol, his smoking, et cetera, et cetera. 10% is related to the stress that the employee had at work. So it was 90-10. And the question is whether or not that met the threshold of the psychiatric case, which requires there to be a certain amount to get to a work-related injury. To make a long story short, what this case tells us now is this: that an employer in California that has an employee that sustains a death and files a claim, if the employee's heirs can find even 1% of the causative factor of the death is related to work, that death is going to be considered a work-related death for the heirs of the employee. And there's a couple of other cases that have told us this as well. It's now just established law, and when I get a death case in, it doesn't mean we don't fight it. What we fight is we have to approve that 100% of the reason this person got a heart attack was for non-work-related factors. And that's been a pretty significant change over the last 3 to 4 years. Fortunately, it doesn't apply to too many cases because we don't have too many death cases in California. If you do have a death case in California, by the way, there are all kinds of reporting requirements now that I'm sure you probably know, both from an employment law standpoint and a workers' compensation standpoint. So if you ever have one, you should consult somebody and make sure you're complying with them all, especially when it comes to OSHA and the reporting requirements. Even if the death didn't occur at work, you have a reporting requirement. So that's short. Do you want to do another case?
Yeah, slide 24 is the Carrillo case. How many of you have holiday parties or a summer party for your employees? You serve alcohol? Not anymore. So I bring that up because it's pertinent to the Carrillo case. The applicant was a busboy at this restaurant. It was a slow day. They sent him home. He went home. He came back after hours when the rest of his friends had gotten off, and he had drinks and dinner in the bar. He's talking to people. He says, you know what, let's go to the patio. I'll be right back. I'm going to get my cigarettes from my car. Goes out to get his cigarettes from his car, and is hit by a car and had injuries to his head, brain, upper extremities, lower extremities, and psyche. And, of course, he filed a workers' compensation claim. So the question is, should the employer be found liable for the applicant's intoxication and ensuing injuries because it condoned the use of the alcohol? Well, at that point, were they condoning the use of the alcohol, or was he just a patron? That's what the defendant argued in the case. Injuries caused by off-duty or social activities involving alcohol consumption is only compensable if there's an expectancy that the alcohol would be consumed by the employer, that the employer knew the employee was going to do that, holiday party, summer party, right? Or if the employer permits alcohol consumption while on the job. Can you think of any jobs that might include that? Very large restaurant chains, involving big sommeliers, things like that. They drink on the job, don't they? Maybe not to any excess, but they do have to taste the alcohol when they're serving it to people and before, right? So that's a job that might include that. And this is the zoo case. And the issue here is this is a home health care worker, and she rides her bike to work, and she rode her bike to and from her home health locations, back and forth, and she was struck and injured by a car, and she was paid for working at both of the locations. So the question in this case was whether or not the transit that the employer, whether the transit was the employer's choice or whether it was some benefit to the employer or the employment relationship. And in this case, the court said the transit was not a commute between home and work, which would have been a fixed location. Me going from my home in Simi to my office in Oxnard, Barry going from his home in Northridge to the office in Encino. That's a commute. This was riding her bike between locations, and therefore the court said, no, it's going to be covered because Ms. Zhu was bestowing a benefit on the employer by getting to her job. It would have been the same if she was in a car. They didn't tell her she couldn't ride her bike to work or to and from locations. If they had, maybe there'd be a question, but unless she was injured less than 70% of disability, I think the employer would still have been charged with having to cover that claim.
So are you saying that if she was driving her car?
She would have still been covered, absolutely. The question in this case was, the carrier said, what are you kidding me? She's riding her bike. That's not covered. She's riding her bike. Why is she riding her bike? That's for fun. But for her, it was her mode of transportation.
Yeah.
Right? Same with the bus.
Yeah, I don't think, in other countries, a bicycle is a vehicle.
Absolutely.
Here,
Right.
it's not catching on that.
No, it's not. In the 20s it did, but it's just different now, right? And I wouldn't be caught dead on a bike on the streets in the valley. Right? Or sorry, I would be caught dead on a bike. That's what I meant.
You might
All right.
watch your tongue.
Right. Well, honest, it's yours.
So we picked this case, not that it's a little bit complicated to understand, but what I wanted to tell you about this case deals with...
Well, honest, 26. Back to 26. Sorry. That's the last time that'll happen.
Deals with how long an employee has to file a particular claim against a particular employer for a work-related injury. Generally speaking, you know that the law is that you as the employee has an obligation to report a work-related injury within 24 hours. What's the punishment for not? Nothing. The employer has an obligation to give the employee a claim form, and what's the punishment for that? A lot.
Yeah.
And you have 14 days to and then you have basically 1 year from the date of injury to file a workers' comp claim. And the reason those statutes exist is because your policies, your insurance policies, are one-year policies, and they want most of the things covered by each particular individual policy. In this particular case, the employee had an injury at work, what happened was the applicant filed a claim within 3 months after the date of injury, named a particular employer because he thought that particular employer was his employer. In fact, it was not his employer. It was somebody else. And they found that out much later. And in fact, in 2011, they brought in the real employer. And the reason they did that was it turns out that the employer that they was originally named had no workers' compensation coverage. So when there's no workers' compensation coverage in California, the Uninsured Employers Benefit Trust Fund pays out workers' compensation benefits unless they can find some other employer with carrier responsible for it. So they wanted to amend in 2011 and bring in this new real alleged employer. And quite frankly, we lose these cases all the time because the Uninsured Employers Benefit Trust Fund is a quasi-public agency, and nobody wants to shift all the burden to those kinds of agencies. So if there's another employer with workers' comp coverage, they want to try to nail it on that person. In this particular case, though, much to our surprise, they said, wait a second.
Montage Insurance. Our mission is to further your mission with dedication, service, and integrity while protecting your assets and giving back to our community.